Hello again, blog readers. My name is Mike DiMarino. I'm an attorney at Seyfarth Shaw, and I'm here today with Jerry Mattman, esteemed class action litigator and partner at Seyfarth Shaw. Now, back in September of 2017, we recorded a video blog that focused on an important emerging class action trend. In that video blog, we discussed the Illinois Biometric Privacy Act. Well, since recording that, also known as HIPAA, since recording that blog, HIPAA class actions have exploded, including a recent juggernaut of a case filed against social media giant Facebook. Today, we're going to talk about that case, and Jerry's going to explain why it's important to employers. Jerry, before we dive into the Facebook case, can you just provide us with a little bit of background information on the HIPAA statute? Why is it important, and why has it caught the attention of the plaintiff's bar?
Sure, Mike. The statute was passed in Illinois in 2008. It slept on the books for a while, but by 2015 we began to see the filing of class actions for alleged breaches of obligations created under HIPAA. To date, there have been over 1,000 class actions that have been filed, challenging either employer keeping of biometric information, things like retina scans, fingerprints, and the like, and also third-party keepers of information dealing with customers, and that is what Facebook is all about in terms of users of that social media platform. These cases are what are called gotcha claims. They involve obligations to give notice, to keep the biometric information safe and secure, to provide protocols for its use. And the cases are beginning to develop and work their ways through the court system. But last but not least, it provides that there's a $5,000 automatic damages cause of action for any violation of the statute. And so remaining questions are who are beneficiaries of these claims, and what is an actual violation, or how many times a violation occurs.
Okay, and now there's been a recent HIPAA class action filed against Facebook. Can you tell us a little bit about that case?
Sure. As configured, it might be the biggest privacy class action to date that's been filed. Although the three plaintiffs in the Facebook case are Illinois residents, the lawsuit made its way to California based on venue provisions, and on April 16, the federal judge lording over the case certified the plaintiff's claims under HIPAA. It involves the face tagging and information tagging systems on the Facebook platform, and the issue will be, given the number of people on Facebook and the omnipresence of that company and its social media platforms, the number of plaintiffs and the potential damages claims could be staggering. So it's kind of one of those cases to watch, and it will be one of the defining moments, I think, under the HIPAA statute in terms of what happens with this particular case.
Okay, great. So the Facebook case was brought by its users. It's more of a consumer class action. Why is it still important? Is it still important to employers?
Well, in my experience, success begets copycats. And so the plaintiff's class action bar is waiting and watching to see what happens if the case is settled, if the case is tried, how a jury reacts to these arguments. I think that although it is consumer-based, it is equally applicable to class actions brought against employers who utilize biometric timekeeping systems, and certainly a majority of the class actions that have been brought in Illinois are against employers given their use of biometric information. To me, one of the seminal issues in all of these cases is a legal concept called standing. What sort of injury is at issue in these class actions, and what sort of damages should be paid for those injuries? Is it a technical violation of the law in terms of keeping that biometric information, or is there a pocketbook injury, an actual invasion of rights of the particular class members or plaintiffs, giving rise to damages. There has begun to be a movement among courts to restrict standing. It stems from the seminal case decided by the Supreme Court called Spokio versus Robbins. And there's been an Illinois appellate court case, the Rockenbach case, that basically has applied these standing defenses to say it takes more than simply a violation of the statute. It takes somewhat of an invasion of rights or an invasion of privacy or a pocketbook injury to establish a valid claim that can go to a jury in this instance. So I think that many people are watching, waiting to see what happens in the Facebook case, and it may well be a template that the plaintiff's class action bar uses going forward in litigating these cases against employers and companies interacting with consumers.
Great. Well, thank you, Jerry, for sharing your thoughts on a cutting-edge class action issue that isn't going to go away anytime soon. Viewers and readers, make sure to subscribe to our blog and follow Jerry and our blog's Twitter feeds and, to stay up to date on the Facebook case and emerging class action trends.